The somewhat delayed because of the relocation, Council Rules Committee will come to order. We'll be reconvened, having been recessed in the prior meeting room. We have a couple of items, procedural matters we have to work through today. About 10 days ago, committee rules committee met, well actually several months ago, we received a preliminary report. Following that preliminary report, which was made available to the public, there were several pages redacted because it contained suggestions, recommendations, and other information. As of today, we will accept, and I guess we need a motion to accept, as a committee. We need to motion to accept pages 43 to 47.
So moved.
Second. Very well. We have the motion. All those in favor say aye.
Aye.
The redacted portions 43 to 47 are now a matter of public record.
Councilmember,
And yes, ma'am.
I would like to make a suggestion.
Yes, ma'am.
If you would name the members of the council rules committee and why certain members are not voting, because this is a committee meeting and not a meeting of the full council.
While we convened with all 9 council members present, the rules committee consists of 4 people: myself, Dave Varner, President Oliver Davis, Valerie Shea, and Dr. Tim Hurley. This meeting today, at this point, is strictly a committee meeting to discuss amongst ourselves that which came out of the Rules Committee investigation, and there will be a couple additional pieces of information which are going to be included if they are accepted by the committee today. So the 4 people, just so anybody, raise your hands who are on the committee. Okay, 4 of us right here, as it turns out in the middle, are committee members. Anyone, after the committee members discuss, anyone from the council can add information, but the council Rules Committee basically will make an advisory-only recommendation after we consider the information today. And if it's, I want to say this correctly, if it's decided to go forward, we have 10 days to review the information.
The committee has
Clarify your specifics.
has to reduce its findings and its recommendations in writing. Once those reports are completed and filed with the full council through the city clerk's office, the full council then has 10 days to hold a hearing, either at a regular council meeting or at a special council meeting, whatever falls within that time period.
Question.
Yes, sir.
When will the public get a chance to speak?
They would have a opportunity at the full council hearing.
Okay. So today, if the public wants to send input to the council prior to that time, how will they do it?
At this point, the 9 complaints, as much information through March 14th, which is the date of the initial report, has been heard.
I know, I understand that, but if the general public sitting here would like to share their comments and everything else prior to that time, how will they be able to do that?
Prior to the public hearing, there would not be an opportunity unless this meeting is continued at the council rules level, and then you could also have public input at a subsequent meeting.
How would that work?
Dr. Varner would have to give notice of the meeting, establish the rules that would govern the limitations as far as duration of input, either by individual speaker or a total amount of time. And again, in the report that was filed, copies of how it was handled in 1986 were provided to the council. And if indeed the council Rules Committee determines that a full evidentiary hearing is necessary, those are, again, separate rules. I gave you the rules that were in place that Kevin Butler, who was the assigned legal advisor to the Council Rules Committee at that time. If you go to a full evidentiary hearing, I would assume that similar rules would be applied at that point, where the full public, as well as the complaining parties, as well as the respondent, would have the opportunity.
But if it's decided to take, that we don't need to go any further, then the public will not need to comment, is that correct?
Right, however, they would have the opportunity at the full council meeting, when the council receives the recommendations.
No matter what, and no matter
Correct.
if we decide to move forward or not move forward, then at the next meeting, then the public
If-
would have.
No, that is incorrect. If the
Correct me.
council rules committee determines that there is not sufficient, the legal language is competent, sufficient, and substantial evidence to prove either a city code violation or a statutory state law violation, it would be handled the way it was handled in 2012, where the committee makes a recommendation that it should not go forward.
So where we are at this point, excuse me, today, is that as we left the meeting whereby we had made some partial review of the preliminary findings, and we received pages 43 to 47, which include the recommendations. It was mentioned, or it was suggested that anyone who had additional or supplemental information they wanted to provide to the council or the committee could make that. I received two pieces of information which have been requested to be added as supplemental. We're going to have a third one here in just a second. Thank you, Mr. Davis. One of which is submitted by Mr. Davis, who is it's a restatement of his statement of February 3rd, 2014. We'll add that to the official record. The second item was requested to receive the special prosecutor's report, which most people were aware. That was received on June 4th, 2014. We'll make that a part of the record. And Council President Davis, committee member Oliver Davis has offered a letter with his assessment at this point. Do we want to take that as this is
Are there copies for everyone?
Yes, I'm about to pass them out to everybody.
As well as the clerk's office?
Yes.
Okay, great.
If you'd like to provide this copy of your letter, can we take these collectively, or do we need to do these individually? Is everyone okay with the notion of accepting?
I'm submitting my summary.
Please, valid, Mr.
Okay, and we have a submission from Ms. Shea.
I'll take two
Okay.
for myself.
So there are four submissions that
Pass
have
them
been.
down. And pass that one down.
I can read mine into the
I'm reading
record.
mine.
Okay,
I can
read
read
mine
mine into the
directly.
record.
let's get back to that in a second, okay? If we're gonna, before you read to the record, I think it's the appropriate thing to do.
Yes.
Okay, so as council, as committee members, there are any?
Hello?
I'm
You
sorry.
need another one? Mine, oh, valid?
Got nothing.
Okay, sorry.
I was going to read it into the record before I passed it on.
Okay,
Is there a copy for Mr. Scott?
yes. You can pass that one on down.
We need a copy for the
Do
official
you have
record also.
Mr. Davis also?
This is also a copy.
Which one do you
Julie copies.
You have one, you don't have one of Valerie's yet, but she's gonna read hers into the record and then she'll pass it out.
have? Okay. So we have a request to add to the record 4 items.
So move.
Second.
All those in favor say aye.
Aye.
Aye, very well then. Those 4 items will be submitted. Now,
So can read into the record.
okay, let me do something here first.
Okay.
To make sure to keep things ducks in order. Is there any council member wish to make or add anything in the form of discussion to the procedural review today for the matter of record that relates to the report as we received it?
That would be included in my record.
Okay, we'll get to that. So there's no one on the council who wants to, are we strictly stuck with the committee right now, or can we ask the rest of the council?
That's up to the chair.
Okay. Mr. Dean?
So your question is relating to the 4 bullet points?
Yes.
On that, and nothing else at this time?
We're strict, right now, we're stuck on bullet point number 1, which is the procedural review and discussion and the acceptance of page 43 and 47, which is now a matter of public record, and the acceptance of the 3 documents, which are a letter from Councilman President Davis, Valerie Shea, and the prosecutor's report from June 4th. Very well. Mr. Davis, would you like to read your?
I'll read mine. South Bend Common Council Committee Rules Committee, County City Building, South Bend, Indiana, 46601. Dear council members, after carefully reviewing the matters that were presented before us regarding Councilman Henry Davis' 2nd District, the following is being written by me to address this situation and to present my recommendation. Point number 1, Apology from Councilman Henry Davis. On February 3, 2014, I was pleased that Councilman Henry Davis filed with the City Clerk's office a copy of his apology letter, which he presented to the public during his press conference. It has been this current Common Council's past practice, as in the matter which Councilman Fred Furlick, 4th District, apologized for his behavior, which was offensive to many in our community, to Councilman Henry Davis in a formal letter to accept the apology and to move forward. Point number 2, request for legal guidance regarding social media and personal emails. Approximately 5 years ago, during the South Bend Common Council meeting Information and Technology Committee, I requested of our City of South Bend and Common Council attorney to provide us guidance regarding the council, the use of social media and personal emails. We requested the need for us to establish citywide social media guidelines and policies that we need to add to our City of South Bend Municipal Code. I have requested and discussed these matters again, most recently in a letter to our Common Council attorney on September 14, 2003, in which we had another council Facebook problem with the council Facebook webpage in which items were deleted on the Facebook page. To date, it is my understanding that neither Common Council nor the City of South Bend administration has established any policy or procedures regarding the proper use of social media, especially by elected officials. Point number 3, Coxsackie County Prosecutor Report reviewed and Common Council Attorney reviewed. The report provided by the Coxsackie Prosecutor Daniel Hampton on May 14, 2014, which all of the South Bend Common Council has a copy, also was very helpful in my decision. The report given to us by Common Council Attorney was also somewhat helpful. There was one reference in the report which used the removal of a state employee who had a similar matter, which I thought was irrelevant to this case, since we are not dealing with an employee, but with an elected official. Further, having the Common Council Attorney serve as an investigator in this matter, also, from my opinion, lended the roles that the Council Attorney is charged with providing the Common Council, especially as it relates to providing an unbiased opinion to Councilman Henry Davis. After observing how this matter has been handled, the Council Attorney should contract out such services in similar future cases. Henceforth, I'm recommending that the full Council accept Councilman Henry Davis's public apology as his official apology, and no further action be taken on this matter at this time by the South Bend Common Council. Sincerely, Oliver J. Davis, Council President, member of the Rules Committee.
A second, Madam.
Thank you, Chairman Warner. I am submitting this letter for the committee and council's consideration. Dear council members, upon careful examination of the information that has been presented to the Council Rules Committee regarding the complaints filed against Councilman Henry Davis, 2nd District, I have prepared the following review and recommendation. The Coxsackie County, Indiana Prosecuting Attorney Daniel Hampton prepared a special prosecutor's report on this matter that was submitted to the St. Joseph County Superior Court No. 5 on May 14, 2014. In the prosecutor's investigation of this matter, Mr. Hampton reports that when determining criminal culpability, it would be easy to identify and prosecute the criminal conduct if the evidence demonstrated that the target had participated in the creation of the obscene photograph or was the original source of the obscene matter. That was not the case here. What the investigative reports reveal is that the target, who originally viewed the obscene material and the accompanying article on another individual's Facebook page, expressed his own disapproval with the obscene material that accompanied an article he exhibited on his own Facebook page. While the target clearly posted the information knowingly, the investigation has led me to the conclusion that the target lacked the requisite criminal intent. The prosecutor continued with, wherefore, upon careful consideration and scrutiny of the facts, the alleged investigation of the matter, it is the decision of the undersigned, Daniel H. Hampton, to return the case as nolle prosequi. Kathy, can I help?
That's close enough.
Thank you. Nolle prosequi is a legal term of art and a Latin legal phrase meaning be unwilling to pursue, a phrase amounting to do not prosecute. Nolle prosequi as a declaration is most often used in criminal cases, but in jurisdictions making use of noli prosequi in civil lawsuits is used by a plaintiff to voluntarily drop its claims. The declaration may be made because the charges cannot be proved due to the evidence being too weak to carry the burden of proof. Because the evidence is fatally flawed in light of the claims brought, or may be made if the prosecutor becomes doubtful the accused is guilty. Next, when examining our city's municipal code for guidance on the city policy with respect to internet use and social media, I found that there is not specific guidance on this issue. However, section 2-8, point P, provides the following guidance for council. Unless excused in advance by council president, persons in the council chambers and in council informal meeting room shall turn their cell phones and any other electronic devices to silent mode when the common council is in session and when standing committee meetings are in progress. Council members and citizen members of any standing committee may not send, view, or listen to any electronic message communications while he or she is part of a quorum for such a meeting. While such meeting is in progress, any electronic device which is used through city-controlled access and which is needed during common council or standing committee is permitted for the purpose of accessing city information, city presentations, and to record minutes and notes. Regarding section 2-210.1A and the council standards of conduct, and the question before the council rules committee on this issue, Council member Henry Davis submitted the following statement on February 3rd of 2014. The blog post and accompanying image written by Reunion Black Family was an attempt to start a discussion on a reading that jarred my sensibilities. Although posted to my Facebook page, it is not an expression of my personal or political views. Many people have found it offensive. It was a mistake on my part. Second, for that I am truly remorseful and I ask for your forgiveness. Social media has the ability to bring people together and it has the ability to create division. Based on the Special Prosecutor Daniel Hampton's recommendations of noli prosequi, the absence of municipal policy governing the use of social media, and Councilman Henry Davis's prompt attention to remove the post and issue a public apology, I am recommending that the full council accept Councilman Henry Davis's apology as his official apology and that we conclude this investigation. Sincerely, Valerie Shea.
We've accepted pages 43, 47, and we've accepted these two letters and the two other items to make the record complete. Is everyone comfortable with the notion that the record, is that our question, Dan? That the record is complete at this point? Do you have any objections?
I would request that Councilman Henry Davis also, we specifically asked, throughout this proceeding, we have asked whether you have anything else to add besides the letter that Dr. Varner mentioned earlier.
No.
Thank you.
Just one second. So the question is, do we accept now as a complete record to the best of the date, to the best of our knowledge, this information? So we can call this a complete record.
I do have one question.
Yes, sir.
Will the other members be presenting from the Rules Committee any letters too, or is that necessarily required?
No, not at this level. It's just the council rules.
When would that be required?
When there's a full hearing before the common council.
Okay, thank you.
Second item, then we'll back to the purpose we consider the record complete at this point in regards to.
Dr. Varner,
Yeah.
and again, in light of the way the city code is written, when we had the opportunity to talk about the deliberative documents, which are now a matter of public record, the question was raised whether the Council Rules Committee believes that it has to go to what we basically called an evidentiary hearing, where you have the ability to take sworn testimony, additional documents beyond that. I just want to make sure for the record here that, number one, if you believe that the record is complete, as Dr. Berner has stated, in that we are waiving, and in particular, Councilmember Davis is waiving a full evidentiary type hearing.
So moved.
Second.
What I'm going to know is that the, and just so we understand, my understanding is that we believe the record is correct, and we believe it's not correct. We believe the record is up to date as it can be, and this is all we wish to accept. Are we prepared at this time to go forward? Without an evidentiary hearing, which would present more evidence.
Correct.
It's the negative the way Kathy stated. So if you're comfortable with
Yes,
that,
sir.
if you're not looking for any more information to make a decision, then we can, we need a motion, we have a motion.
Motion,
you have
so,
a motion.
second.
That we move forward without the need for an evidentiary hearing.
We need a motion and a second.
We had a motion and a second. So all those in the committee that are accepting of that, say aye.
Aye.
Opposed? Very well. There will be no need for an evidentiary hearing. We will make a decision based on the information we have in the record and the recommendations that have been presented. Mr. Peters?
Is that a recommendation from the committee to the full council, or is the full council able to weigh in on that?
Again, in the past, when there was a full evidentiary hearing, the full council had the opportunity to do that. Again, it's up to the chair whether comments, typically it would be the council members that are on the council rules committee first, and then any other additional council members.
But the full council cannot vote on that tonight, though.
Not unless all reports are of record with the council.
And they're not all over record tonight.
Not yet, because you have a couple more steps that you must go through.
Okay.
Which are,
Did you have a question?
excuse me,
Two, and we have to go to.
what steps do we have to go through now?
At this point, I believe Dr. Varner is going to move right into determining whether there is anything of record in what you have completed as a complete record, whether there is sufficient evidence to go forward with regard to any violations of either the city code and/or statute. That is civil in nature, not criminal.
Right. The letter from the prosecutor has ruled out a criminal. So the question is, as Kathy stated, I believe there's a reason to consider a civil discussion on the civil charge or civil question.
I move that there is no discussion to continue that on civil matters at all.
Second.
We have a motion and a second that there be no question, there would be no action on a civil. Did you say that right?
Right.
No action on a civil discussion of civil. All those in favor say aye.
Aye.
Opposed?
Nay.
I'll give my. So we have a,
A tie vote,
We have a
and
tie vote.
therefore the motion fails.
So we have a discussion, or what do we do?
Yes, you have a discussion, and again, as I pointed out in my June 5th memo to you that gave examples of supplemental reports that were filed, similar to what Councilmember Shea just did and Council President Davis. You can continue to deliberate. You can also go forward with regard to a timeline of events because specific findings have to be made by the committee. And if you cannot come to a full majority of those, all of those findings still have to be reduced to writing, your conclusions as well as your recommendations. Technically, right now, 2 of the members have provided your findings as well as your conclusions and recommendations. And 2 members still require.
What is the deadline on the other 2 members from providing them, given the fact that we all were notified at the same time?
It's my understanding that this is going to continue now.
yes.
True.
Question, I have a question.
Yes, sir.
Everybody was supposed to show up today with their letter. No one was,
No.
No, it was everyone
No.
was supposed to be here for the hearing today. And depending on where we went forward, a letter eventually would be necessary if you chose to add a letter to.
I had a different
then
understanding.
that's not an understanding I had, because I was asked to bring a letter in as well, and obviously Valerie and Albert brought their letters in with that same understanding. Not that we talked over the phone about putting something together, but that was what the agreement was upon leaving that room. that day that everyone was supposed to come back with a letter in hand for today's meeting so that we can move forward with this. And as a matter of fact, here we are again talking about some more time. So I'm just a bit confused on why only certain people are responding.
I will tell you what my understanding is.
Okay,
My understanding was that we would go through the steps that we had here today. If there's any more evidence, we've gotten through basically the first two steps. And this was an opportunity, and what I believe I asked you was if you wanted to provide anything that's supplemental. You and Valerie and Oliver had chosen to provide a letter which was supplemental at this time. At some point, we have to reduce everything to written finding, and that would be when I would put my thoughts right. Well, we have a 2-2 vote with regards to where this goes from here. Just one second. So I want to make sure we're in the right. All right, Valerie, go ahead. Ask the question.
Council Attorney Skansky, can you give us an estimate of how many hours you've invested in this investigation?
Well over 100.
Approximately, what is the billable rate that we pay you?
Based on last year's rate, less than $38 an hour.
So 100 hours, so we've spent about $3,800 in legal fees so far on this?
You pay me a flat fee regardless of how many hours I put in.
But based on what we paid you last year?
Yeah.
Okay, and then what would you guesstimate as an attorney, how many hours do you think the Kosciuszko attorney invested?
I could not, I do not know how many people he interviewed. I do not know the depth of this interview. It's a totally different standard as opposed to the 9 complaints that are pending before the council.
Would it be reasonable to assume that he might have also invested at least 40 hours of billable hours?
I don't know.
So we could estimate that maybe $3,000 worth of legal work was
It is my
done.
understanding that the Indiana State Police did the initial investigation.
Okay, so in terms of burden on the taxpayers, we're already approaching $10,000 for this investigation. That's, in my opinion, shameful.
Okay, thank you. So with a 2-2 vote, at this time I haven't provided anything in writing. If you'd like me to make my thoughts, I'll be happy to make them.
that would be great.
The summary is provided by our council attorney, listed what was a factual basis with regards to time and date, and we will have summaries of those available. It lists events. It recognizes Mr. Davis's apology. It recognizes his actions after the fact. The state police report and the prosecutor, although there was no recommendation of prosecution, clearly identified material as obscene. I find most of the objections I've had or listened to from constituents dealt with the issue of obscenity. With regards to the civil consideration, as stated in the reports, we have to set a standard for ourselves as council people. An accident while driving impaired is an accident nonetheless, and something for which people find themselves subject to consideration of sanctions. I would make no judgment whatsoever with regards to intent. I think the prosecutor did a good job of defining that. It was the nature of the posting. There are no rules with regards to, and Mr. Davis made this clear, and I agree, we need to do something about this with regards to the use of Facebook and the rules and the guidelines for that, and we have been apparently shorted ourselves with regards to that. But I find the nature of the posting as identified by the prosecutor's office to be as obscene, and I think that warrants a sanction, and I think as we discussed Friday, I think that warrants a censure as a consideration. So I didn't reduce it to writing. Those are my thoughts at this time. this information which has been provided, it certainly I appreciate that, it'll be made part of the record. The other council member is Dr. Bertoli. Offer any thoughts at this time, or would you rather wait till we?
I'll put it in writing, but I think that I second Dr. Varner's opinion in that essential is probably in order. But I'll put that in writing.
Can I respond?
Well, no, everyone has made statements. Everyone's had a chance to make statements. Okay, sure, Mr. Davis, go ahead.
Number one, to go back, we're all professionals, to go back and to charge somebody with an event that there was no law on until they happened is really illegal. And to come back and do that, I think that's something, if we were to, in your dental practice, on your medical practice, or in anybody's practice, if you were to say, well, I don't like that, now we'll make a law after that to punish that person, after that person has done that, is not really professional. And number one. Number two is the fact that when we have asked repeatedly of this council and this technology committee and administration for us guidance regarding this, and it was silent for several years. When I've talked to them about it, because so many people started communicating in our districts to us on Facebook. Some of you don't even look or use Facebook, but for those of us who do, people ask me, hey, my yard's not cut on Facebook, or I need my trash picked up on Facebook, or I need this one. They send, so I asked this council, what is guidance, since this is my private email? I use when people are sending me, we asked this council, and we asked the last administration legal. And the fact that this has been silent, and then we come back to Mr. Davis, and then we're going to make a Henry Davis rule, I think it's inappropriate. Okay? Secondly, with all due respect to Dr. Furley, when Dr. Furley called our dear colleague a drug dealer, and then he said that he apologized, which was highly offensive for many of us in the community, highly offensive. But our council, our legal attorney, found that that was appropriate for us not to move forward, and from that standpoint. And so we did.
It was a joint decision.
It was a joint decision by
legal
me.
department and
It was.
myself, and it was an advisory recommendation.
It was an
to the
advisory
council.
recommendation that we had, okay? But the advisory recommendation that she had on that was completely different from the advisory recommendation with this. And that was highly offensive, okay? And so therefore, and punish Henry Davis, while we did not punish Dr. Furtick for doing that, is a double standard. To have a double standard in this community at this time does not present the kind of council that we should have. And so for Dr. Furtick or anybody to say, well, oh, he was just, that was something he said off the cuff on the way. This is something some person said when they have a discussion on their own private Facebook. Are we going to sit back and start monitoring everybody's Facebook? Am I going to monitor the times you get drunk with your girlfriend, or get drunk with your wife, or get drunk in your family life? How much are we going to take the time to monitor all 9 of us on our private matters? That's a key question that I really want us to look at when we talk about doing any censoring. Because when you look at Reconstruction, when you come down to those kind of issues, there was a time when this country came back and put many of our leaders who look like me under a lot of different kind of causes. And that is just wrong. And that's not just because of black or white. I mean, I represent a different district, and so many people all across this community have said, we have taken too much time. We had, my final comments, we had a situational report. The police officer made a comment on their Facebook that was, the union took as a very offensive. Their attorney didn't even waste time and spend all these thousands of dollars. He moved on, okay? And so when that just happened to us, here we are wasting this amount of time to try to punish, because there's some hidden agendas about people who do not like Henry Davis.
Come on now.
And so, Dr. Furlick, and for anybody else, we respected when you said apology. We respected that, and we moved on. Yet we would not respect when Henry Davis says, and I have a serious fairness issue with that issue.
That's right. That's right.
I've had a lot of stuff in my life. My family has gone through all that. Maybe some of you haven't experienced that. But even when we had Mr. Joe Shabazz situation that we had, and some of you felt that that was very offensive for what he said, and he was removed we removed him out of office because of his statements. We removed him. And our attorney felt very offended by what comments he said. But yet, when this is shared, this is not given the same fair treatment. We have to be
That's why,
Dr. Furley.
first of all, I don't think there's any criminal intent here on Henry's part. And second of all, I think you all know me out there. I treated half of you.
No, we don't.
That, well, you may not know me, Mr. Bonds, that's fine. But that was within the first month or two of council meetings when I said that to Henry as a joke.
You didn't make it right.
You may not take a joke. Any of you that know me, whether it be at
All right,
Central,
okay,
You didn't make
this
it
is
right.
Dr. Furley speaking. Let's keep it, please keep it quiet in the audience.
it was addressed only to Henry as a joke, and I'm sorry I offended him, but I meant it only as a joke. So, but just let's say, I don't think there's any criminal intent on Henry's part, and I think the basic thing we gotta figure out is how to help Henry, the council, and the community, okay, heal this all.
Yeah.
And it doesn't have to be draconian, but there has to be some civil action taken so this doesn't happen again.
My question would be then, Doctor, why would some action have to be taken to kill the action for Mr. Davis when there was no action have to be taken to do that?
We've got one subject for discussion.
No, it's all one subject. It's fairness.
Actually, it's.
We've talked about fairness.
No.
And this is not being fair.
The agenda tonight was not.
First Amendment.
It was specifically dealing with an issue brought by a complaint, which we are obligated to address.
But with all due respect, Dr. Varner, our attorney in the document that we said has utilized the whole case that we had. What was the attorney, what was the councilman that we used this to base it off of? PASAC. So she has used PASAC as a part of her recommendations. So I am
That is,
using,
if I may,
I am using our last council rules committee as a part of mine, and it's all fair.
That's
And
right.
so that's a part of the
That's in
record.
your letter,
That's
it's not in
right.
your letter, but it's part of your recommendation, and we recognize your recommendation. And Valerie, we recognize your recommendation.
right, and just for the record, I have copies of what was taken, the action of the Council Rules Committee, September 24th, 2012. There was a stipulation of facts that were signed by both Councilmember Davis and as well as Dr. Furley with regard to that. That matter was referred to the legal department, then acting interim city attorney Aladine DeRose and myself were asked to give an advisory recommendation. We gave you a legal opinion at that point, and it was not binding on the Council Rules Committee. The Council Rules Committee deliberated, as you are now. The same procedure is being used today as was used in 2012, as was used in 1986.
And that's where Dr. Furley, that's why I'm referring to that matter, since it was our last matter, and therefore it was agreed to.
And it's noted, just one second, and it's noted in your letter that you made a recommendation. And Valerie noted in her letter that she made a recommendation. We have, at this point, in the agenda, a two to two, which the motion was made, it failed. So in order to move forward at this point in time,
There are specific findings that I'm assuming that Councilmember Shea and Council President Davis, you have assumed that your findings, conclusions, and recommendations are in your supplemental report. Is that correct? At this point then, Dr. Varner, I believe, has a draft of his findings, recommendations,
what we have is a summary.
which sets forth a timeline. Again, that is what was used in the past.
In order to look at the whole picture, I thought a timeline, start to finish, including all information, was important. We have a timeline which takes us up to today. If you're willing to accept this, we will make this a matter of the public record, and we will make it available for public download.
Before I can accept it, can you,
Oh, sure. Well, yeah.
can you state for the record that this is something you prepared independent? Council Attorney Sikansky did not prepare this for you.
Oh, absolutely. I asked Council Attorney.
It was based on the report of March 14th. as well as the
This is not
Passay
a
House
report
part.
that you prepared independently. So I can accept that.
Okay.
I cannot accept it.
Then we have,
Hold on, I'm confused. I'm back.
this is nothing more than a timeline and a summary of the facts which everyone has in their
Well,
position.
but wasn't that the same, is that part of the same,
We began this with a 125-page
No.
investigation with 40
I'm
or
not
4
done.
pages.
Can I talk, please? I was trying to ask you a question. Is
I'm
that
sorry,
part of
Mr.
the same packet of paper, or from the same packet of paper that we received from her initial investigation?
No, it's not.
No,
It's a summary of it.
So it's a summary or derivative of the packet that you gave to us?
it references pages within the preliminary review that has been off record since March 14th.
So, what my question I'm asking, because I want to be clear too, that has not been presented to anyone else but to you and also to Kathy, or has anyone else read that?
No, we're making it available now.
Oh,
Summary.
So you're asking, and I'm unclear, so I'm asking. So you're asking that be made a part of the record, or be taken in as record, or be voted upon as record? I guess what I'm asking is that you're asking the committee itself to vote on that summary as what?
What I'm doing, I'm making this available as a summary as we review the 125-page document, plus the pages which have now been made available, which was the redacted pages.
What's
The timeline from start to finish, including all of the activities, is easier to follow than a 125-page document.
Can I make a motion that we
No,
look at this?
I'm not done yet.
No, I'm answering the question, so you're done.
Can I make it?
Until I finish answering.
You don't need a motion to review it, so we can all review
You know,
it?
just like the supplemental reports were given, it doesn't have to be of record. However, Dr. Varner is willing to share what his conclusions, findings, and advisory
It's not his
recommendations are.
recommendations, it's yours.
So actually,
Yes, exactly,
You
exactly,
voted, it's
Okay.
yours.
She get the page out.
We're absolutely right.
exactly.
Absolutely right.
So now.
this, a lot of people put a lot of time to try and make this as open and
That's inappropriate.
fair as we can. Mr. Davis was offered an opportunity to provide additional information. He provided that. Mr. Davis, Oliver, president, was given an opportunity. He provided it. I thought a 125-page document is a little hard for everyone to digest. You're welcome to do so. They're available. A summary of the facts and the dates and the times, which gives everybody a timeline, puts a lot of things in perspective for the sake of consideration. Those who wish to look at it and consider it are welcome to do so. It doesn't contain anything different than is in there. It's a summary form.
No,
Where is it available?
Hers, not
No,
yours.
I was just asking for understanding where this is headed, because I didn't know if the vote that you're asking to be taken right now, or, yeah, the vote that you're asking to be taken right now, would in fact say that everyone's in agreement with what's on that paper.
No.
But it's not, you're
It simply accepts it.
it accepts what?
It accepts this for the record as a supplement.
As a supplement. So if they do accept it as a supplement, that's the only thing that we have to refer back to, given the evidence that's before us right now.
No, it's an addition. It's an addition. It's part of the record. If someone wants to read the whole thing, they can read the whole thing. They want to review the summary first and then go back.
So it doesn't take place of the initial report from the
No,
beginning?
none whatsoever.
You're submitting it as your.
No, I'm submitting it as additional information, which is, I see this as being something that people can look at and review and put everything in perspective in their minds, however they decide to assess it. But it's a timeline, it's accurate, it's a timeline that I think is complete. It's a timeline which allows us to reduce for consideration 125 pages, some of which is information that was from a previous circumstance.
Well, sure. And the reason why I'm asking that question, I want to make a comment as well. The reason why I think that there is such a drawback from this is because we have never gotten to this point when we're dealing with council rules hearings. Since I've been on council for 6-7 years, I think there's been a matter of 2 or 3, which is kind of a lot, but neither here nor there we've had those. And so I guess the reason why it's being questioned in the manner in which it is because we're still taking steps towards something that we really don't want, a place that we don't want to be at. And we're also taking steps on something that has obviously been sort of investigated a few times already by outside entities. So why are we still building a file if we can't or we're not going to do anything different than what was already been said by a prosecutor outside Costa County and other places? I mean, why are we continuing on the conversation?
Right, amen.
All right, and I think that's what the reason, that's why I'm asking these questions, because I'm stuck there too. Why are we still talking about this? Why is that still an issue?
All right.
Well,
Get it over with.
No, actually, Henry's asking me a question.
That's a legitimate question, right? I mean, that,
I get the question is fair. The problem is, we haven't resolved this yet. And when it's resolved, I think then all the questions stop, the issue stops, discussion stops, everything stops. The question is, can we resolve? That's what we're trying to do. I promised a fair hearing. If it takes time and information to do it, it'll take time and information. But if this is, I'll make this summary available to anyone who wants to use it. It doesn't have to be part of the report. We can do it that way for anyone who wants it. Okay.
Are these documents online, or do we have to pay for them at the city attorney's office?
I've got a copy you can have.
Make it two.
Mr. Peter.
So regarding this summary, as President Davis and Councilmember Shea put them into the, I guess, the record, this will not be in the Rules Committee record?
No, it will be in the committee record, not as an official supplemental report, but anything that's distributed to the committee, just like any other standing committee, that becomes part of the public record. That is not an official document.
So what's then
If,
I guess the difference between the things that were accepted by this committee as opposed to this piece of, or this report?
both Dr. Varner and Dr. Furlick have stated that they believe that there is basically sufficient evidence to go to the next step, that there should be findings, there should be an advisory recommendation made to the full council. What Dr. Varner has prepared, asked me to assist him in preparing, is going to that next step. And if I could just point out to Councilmember Henry Davis, the reason why we are here is because 9 complaints were received by the Office of the City Clerk alleging violation of the city code. That is totally separate and distinct from anything that was reviewed by the prosecutor.
that, I understand that, and I appreciate that you're trying to stay on the same course. But the problem that comes out of that same conversation, the 9 members, we've talked about this, is that out of the 9, maybe 1 had access to the Facebook page. 4 or 5 of them didn't show back up for their interview with you. And out of the 3 that lasted, again, only 1 had a Facebook page. The other 2 had never even had a Facebook page. So there was a question on how is a person allowed to manufacture a complaint in the story on any of us. It's just not me. Honestly, on any of us. And then we as a council take out 6 months out of the year to figure it out. On top of that, spending more money, and then we can't get the work done we're supposed to be doing because of that. And I think that's the biggest issue. It's not about Henry Davis. It's about how people are allowed to manufacture stories and then try to get us to try to prove it. And now all of a sudden now we're trying to figure out how we get out of it because it becomes a public relations nightmare. So I'm being honest about that. How does this work? So I can just say Derek Dieter beats his wife, and I get 5 people out there to do it, and now we got to do an investigation. That's ridiculous.
It is.
I
The statement was ridiculous.
don't think,
All this is
You're
ridiculous.
ridiculous.
we'll clear the room if we have.
All this is ridiculous.
You're prejudiced.
I'm saying, I didn't mean to offend Derek. I'm not trying to, I'm just saying all of this is ridiculous. It is, all of it is ridiculous. And so I'm trying to get you to understand where I'm at. I mean, it's not a good feeling to continue to talk about this. It's nuts. You know, I can find other things to do with my time. I'm sure you can too as well.
I'll go back. I promised a fair hearing.
Fair.
But who was it fair to?
Where's your
It's
sheet?
fair. It's fair. We're following the rules. We're following precedents. We're following the law. We are recognizing documents that have come towards us, that come to us from former investigations. You have made your side on the circumstance very clear. In my case, I looked at the prosecutors, which was totally independent, and the issue of the use of the obscenity is where I have an issue. You and I will have an issue on that. We will get it
Well, it's
resolved.
generational.
We will get it-
But it's generational. I keep going back to this
This is-
too.
this
No,
is-
no, it's been
All right.
generational. And I'm not, what?
Davis.
That's not, I don't do that with
You asked
you.
me a question and I answered.
But I don't do that with
was
you.
answering.
But I don't do that
Let
with
me
you.
finish.
Well, you can finish, but I don't do that with you.
Yes, you do.
Are we arguing?
No, we're not arguing.
Okay,
I'm
well,
not a
okay.
meeting.
You
and
can
this is
carry
where
on.
we're going. We have issues with regards to this. We probably will have issues when it's over, but we will take it through step by step, unless we reach a consensus some other way.
Well, that's what I was getting at, because the issue is, I can talk about being generational with social media, but also I can talk about, again, what Oliver was hitting at the point that if precedents have been set, then why won't we refer back to the last 2 or 3 council committee hearings that we've had? And use that as our precedents rather than going to find something else that follows all the steps.
I don't know.
And I think that is the hiccup. Honestly, that's the hiccup, because giving Dr. Furlick and myself, the one prior to that, and I think the one when Oliver had just got on council, President Dieter then said that he had broke some rules. That was investigated. We were in the back room. We said all things are clear, we're fine, after he had got an attorney, and we were done with it. And so those were precedents that were set per the recommendations of council attorney as well. But here we are, we went to 1 step, 2 step, 3 step with those situations. But with this one, we're going, okay,
4, 5, 6.
1 to 20. And we're still trying to figure out where we're gonna go next with it. And I think that is the confusion, because why are we continuing to further this along if we're trying to follow precedents?
Where do we go next? We have an agenda. We have an agenda which lists 4 items. We did not reach a determination with regards to whether there is sufficient evidence to move forward. Do I have that correct? Was there a motion?
There was a motion that failed.
Okay. And it was 2 to 2. It failed because of the tie, not
Correct.
because of being defeated.
Correct.
Okay. We have an impact with
And
regard to that.
Right, and at this point, both you as well as Dr. Furlick have given your opinion.
Right.
You have proposed findings. Both of you need to reduce it to writing or amend what has now been circulated.
And we have 10 days
Correct.
to offer, which it will be 10 days.
And again, once those report are all of record with the city clerk's office, that is what triggers the 10-day period that the common council would have to hold the hearing.
Is there a time limit on that,
The time limit,
when those other 2 letters have to be in?
you can establish it.
I think
Do
we
I have
should.
time limit?
I think we should.
10 days? 5 days?
I would just like to see so we can have it on the coincide on the next council meeting.
See what I'm saying? Just coming up with stuff as
No,
we
no,
speak.
oh, please. No, I just want to coincide personally with our next council meeting so we can take all of this done and take care of this month.
Okay, so what's that? Because we're in an impasse, because we have no recommendation, we will not be able to make a recommendation out of the committee.
Oh, everything still has to be in writing though,
Okay.
and that will be transferred to the council.
Just for those 2. And point of clarification. So everything that needs to be reduced in writings, again, the conversation at this point is only at the committee level.
Correct.
Other council members have not weighed in.
Correct.
And so we will not make any comments until we have the committee's recommendation, which would include in written form from Dr. Furlick and from Councilmember Varner. And we probably, I would suggest, I'm just clarifying, so I'm not making any recommendations, that time span be as short as possible.
And again, Council President Oliver Davis has suggested so that it could be
Yeah,
within the next regular
because
common
if they
council
can,
meeting.
if it's 14 days to the next council meeting, so in the next 4 days, if they can get that in, then that would give us 10 days. And then at the beginning of our next council meeting, we can clear up, we can deal with this, make a recommendation, and solve this matter here, because we need to solve it.
Would it be, just one second now, would it be fair to, so that the fourth point we have to deal with today was discussion of advisory recommendations. It seems as though recommendations were in the original document. Recommendations have been made from Ms. Shea, from yourself. There's no need to discuss advisory recommendations unless someone wants to add something to the information that's available with regards to advisory recommendations.
Can we get a commitment on the committee level that the letters that
Oh, yeah.
you and Dr. Furley are writing are going to be independent and not drafted by council attorney?
No, I will see council, I will see council right there.
I also.
So these will be your own opinions, not that of the council attorney?
They will always be my opinion. All right then, I guess absent the ability to come to a decision with regards to, we did agree that there's no need for an evidentiary hearing
Correct.
also, so that was, we just come to agreement on that. I will have my report in for the next meeting, Dr. Troy will have his. Will they need to be accepted then as part of the, or will they simply be included because we're expecting it?
You have both written your opinion, or excuse me, verbalized your opinion. It would supplement what
Okay.
you had verbalized, that would have to be filed with the clerk's office so that it can be heard at the next regular common council meeting.
And just for sake of clarification, at that point in time, we will have four opinions from the committee.
Correct.
That's a question. We'll have recommendations from the four members. We will officially have to make some sort of recommendation, which can be anything from yes to no to no recommendation. We could reach some sort of agreement. And then it goes to the council, and that same day, council will have to hear it. Is that correct? Or is it-
Basically, your written opinions are, all four of them are going to the council, the full council.
Okay.
The council will then have everything of record, everything that was submitted today, the four statements, the council preliminary investigative report, as well as the two that are forthcoming.
Then, without anything else,
And the rules, again, that would apply, I'm assuming, are the same rules that we've only had one full hearing before the common council. And those were developed by totally separate legal counsel, not myself. And those are in the full report that were given to you in March.
very well then, we've gone through all four of the bullet points. We have no decision that we can arrive at. Mr. Davis.
Could you please clarify for us since we will not have an evidentiary hearing, what does that mean, since we will not have an evidentiary? It relate to this whole matter.
Basically, that there has been a waiver to calling any additional witnesses, having them under oath, having any additional documents of record, that based on what has been heard by the Council Rules Committee, anything that was filed officially that's of record with the Office of the City Clerk is the information. That does not eliminate, going back to Councilmember White's point earlier, that everyone has the right to issue an opinion. And that would, you have that opportunity then at your next regular common council meeting.
Would that be a written opinion that everybody has the right to do,
No,
or a verbal
that
opinion,
is
or what?
That is verbal.
So the other members of the council would just have to just have to voice their opinion.
Correct.
Okay. And then after they voice their opinions and we do this kind of matter, then what happens?
Then there, again, as summarized in the prior hearing, there were 7 different votes back in 1986 before there was a consensus of the common council.
Consensus being majority vote.
Majority only, yes.
So there were 7 recommendations.
There were 7 formal motions, debate, deliberation.
Mr. Dieter.
this is all, everything that Dr. Furley was talking about is committee.
I'm
Comes
sorry.
out of the committee's recommendation to the full council.
Right.
Right.
And everything.
As far as now, because on the summary from the prosecutor, there are two cases, one from the Indiana State Police, one from the South Bend Police, that aren't part of the record.
Correct.
Their recommendation that all documents are now
Complete
from the committee complete.
from the complaint.
The full council or anybody else from the council would be able to introduce those.
If we're following the same rules, the guidelines that were used last time, I'm sorry, that's not correct.
1986.
1901.
The rules that were used on July 21st, 1986 were read into the record by myself. It confirmed all documents of record. The procedure then, it set time limitations that pursuant to the municipal code, no testimony or other evidence can be heard. Only the final closing statements. A total of 10 minutes was then given to the representatives of the complaining parties. Councilmember Pasek or his legal counsel, who was Mr. Vic McFadden at that time, then had 10 minutes to give their response. A total of 20 minutes was divided into 10-minute portions to enable those speaking in favor and those in opposition. The council portion then took place where they deliberated on all reports from the Council Rules Committee. There was no further input from the public. Again, remembering that back in '86 there was a full evidentiary hearing. A formal vote as to whether to affirm, modify, or reject any or all of the reports from the Council Rules Committee would then be taken. All remaining supplemental reports were then discussed. Then a series of public input. The final vote that was read into the record by then City Clerk Irene Gammon read a statement of public censure into the record. All motions for removal from the council were defeated.
Question on that, to our attorney.
Can I finish up? It's better. So, my question is, there's two reports which are in the summary from the prosecutor that we don't have access to, so they won't be part of the record.
The only way that, if they are public records, they may need a subpoena. If they are investigative reports, or they may need APRA, a public access record request. And again, I'm not sure what would be required of either the Indiana State Police or the prosecutor.
But as far as the committee,
The committee's
Decided
record is complete
they don't
as of
want any
this
more
point.
documents.
That is correct.
Can't put them.
Pardon me?
Karen, Ms. White?
Yeah, I have a question to our attorney. Since we're not having that hearing, okay, the steps that were in 1986,
Correct.
okay, would those steps still be needed? Because it seems like a lot of what you just shared was in response to having that hearing. So again, I want to make sure that when we come back in 2 weeks, that we have a clear understanding of the process, procedures, and what we would actually be doing when we come back.
Basically, there was an equal amount of time was given of the council member that was charged with the violation.
Okay.
And again, they had a separate legal counsel for that evidentiary hearing. So here, I think it's incumbent upon the council to make sure that there's an equal amount of time for those from the Council Rules Committee, number one, to the full council. You'll have all of those reports, so those will speak for themselves. Basically, you just need to identify what the rules would be for the public input, if any. And then it's simple majority of the council on a motion-by-motion basis.
Mr. Davis.
Okay, thank you. Couple of things. Number one, wasn't the action that Councilman Basic was accused of, didn't that take place in a council meeting?
No, it took place in his home.
Took place in his home?
It was an interview with a Tribune reporter.
It was interviewed, so it was based on this freedom of speech issue too?
Yes.
Okay. All right. And the second issue is, since this is going to, when will we have to make a determination since there is going to be questioning or whatever, that this council would need to pay, since we are taking care of your legal fees, when will we have to take care of the fees of Mr. Davis? Because there's no way that, in my personal opinion, that you can legally advise him since you're the investigator on this opinion. So I believe that the council needs to at least give him some kind of legal guidance regarding this matter, and not for him to be acting alone. Because this is his career, and we are asking him to come out of his pocket and deal with all this matter, and over a matter like this. And I don't think any of us should be required to do that.
Councilmember Davis, I was asked by the Council Rules Committee and the full council to provide this advisory report. I am not getting paid a dime more for having done this. I'm doing it as your council attorney.
I understand that.
Number one. Number two, each time that I spoke with Councilmember Davis, and as reported in this preliminary report, I advised him that at any time throughout this entire process, in order to be fair, that he was entitled to have his own counsel.
But my understanding about that, you also had to pay for that too, and that was not, and that's what you also shared with him. But I believe on these kind of matters that the members of the public can come and throw frivolous charges against us, whether they're true or whether they're not, or even real charges against us, in our duty as a council person, and that we're looking at, then we need to then look at paying for his legal fees so he can be given the proper guidance as a council member since he was working as a council person. I just think that's only fair.
That will be a discussion for the Personnel and Finance Committee,
I'll be happy to take that
not a discussion for, in regards to the Rules Committee here today.
But I mean, talking about should that discussion take place with all due respect to that thing, given the fact that we are on a time schedule for the next 2 weeks. The next time we're not going to have another meeting will be to the Personal Finance meeting that same day. You see what I'm saying?
I guess at that point in time, if it had to be continued, if someone wanted to continue it because someone would retire or retain an attorney or counsel, they could do so. We'd probably be obligated to continue it in order for a person to obtain
The one
counsel.
thing that is,
And then,
the one thing that has been the touchstone throughout this process is fairness, and I would hope that Councilmember Davis would agree to that each time I spoke with him, and each time I spoke with anyone that was interviewed for this report, that I made sure that they were advised that they had the right to do that.
Well-
I also advised them as far as what the structure was with regard to the city code, because that is basically what we are doing here. As Dr. Varner has stated repeatedly, it's a multi-step process. We're making sure that each one of those steps procedurally are being followed.
with all due respect to what you just shared, if I've worked with several attorneys, and when I share with my attorneys the situation that's going on in my life or what's going on we're dealing with, they do not make a report and submit that whole entire report to a council for an investigative role. And that's kind of standpoint. Okay?
All right.
And so my point to you, I recognize where you are with that, and you and I have talked about this in this sense. But in all fairness, this is not a new topic. When you have moved to a role of investigative role, and then the issue that he shares with you becomes a public document, then he does not, there's some things he may need to share with an attorney regarding what to say, what not to say, or how to say it, and when to say it, and all that kind of stuff, that it was your role as an investigator, you will not be able to provide him that when you're actually making a report. I don't know any attorney that can do that. I am a therapy role. So that's what I'm saying to you. I think that we have to really consider that, because my concern is that we will push this movement all the way to 2 weeks, and then we say, well, Personal Finance Committee has to make this decision with all due respect to that. They're not going to meet until the same day that he needs to have an attorney in preparation of these next 2 weeks. And that's not right to not have somebody in this Freedom of America to give him not 2 weeks of attorney. So that's standpoint. That's not fair.
Okay, here's where we are. That's not a decision the Council Rules Committee makes. Not tonight, not here. That's, I believe that's in the past, that's handled through a petition from the council member to the council with personal and finance. I mean, the request is made, it seems to me, in the past, there have been requests for support for leadership. That's not what we're doing here today. Where we are, at this point in time, and we're going to adjourn this. We're discussing things that are not relevant, that are relevant to maybe another discussion, or are not relevant to the discussion we're having here
The only
tonight.
thing, with all due respect, I'd have to call a question on this. When we've had our last two rules committees, I was also challenged in the first rules committee, back to precedence with Councilman Davis, this is why I have a passion for this. Former President Jeter also challenged me in a meeting, and he himself, along with counsel from, must have been from my attorney, said that I could not get an attorney at first, okay? And they made that decision. I have been, when I talked to our council attorney, I asked her, well, by what authority did Council Jeter make that? He said he made it on his own, and he talked to her. So my point to you, that was in a rules committee. I had to go out in a rules committee and pay for an attorney, and then ask you all to do it and pay half of his cost. In the last situation, we've had to deal with that. So when we have come to rules committee issues, and this is where I've been trying to advise Councilman Dave, this is not off the subject at all. When in the last ones, I first was challenged, and Councilman Dieter shared with me that they were not going to pay for it, and he was president. Now, when I have to become president, it is also, no, it's not the time because of the fact that when you were president, you just said I didn't have an attorney. Why? That's why. No, seriously, sir. You asked me, I'm referring back to Rules Committee. You're the president, you're the chair of the Rules Committee, so I'm referring back. I'm not referring back to any other committee.
And I'm saying the question was, if there's going to be a rationalization and justification for that, Mr. Davis can make a request, and it will be handled. Tonight is not tonight, we make the request. We have an agenda, we've been trying to work through it, we've been trying to be fair, and give everyone the opportunity relevant to the agenda that we have here. So I think we've done a pretty good job. What we need to do, because we now know where we are, is that there is no consensus. There is no, we will not have a full evidentiary hearing. We will conduct, or we will submit reports as required. Dr. Fulton and I will do that. All the reports will be in at the next meeting, by the next meeting. At the next meeting, when council rules meets, we will have to either have a recommendation in favor of something, or a recommendation which goes to the council with no recommendation. And at that point in time, it moves to the full council.
And the full council then has what type of authority based upon her recommendations from her?
No, based on the city code.
Right. Yeah. We're trying to follow.
There is nothing in the city code on this.
The meeting, we will have our submissions in. This is where we stand. The meeting for now is.